Personally, I'm finding the changes happening in the legal industry really exciting. They bring together my past as a practicing lawyer with my experience over the last 20 years, helping clients get value out of outsourcing relationships. The facts are that the business of law is changing, and it's changing in a fairly permanent way. Technology has caused a tremendous explosion in the number of documents that lawyers are having to deal with, and automation is helping bring some of that explosion under control. But it is definitely changing what lawyers do. The number of competitors and the kinds of competitors that law firms are facing today is also changing dramatically and causing lawyers to change how they practice. And the dissatisfaction of clients with the billable hour has reached such a point that, again, something needs to change. These big transformational pressures have implications for the leverage models that law firms have, for how firms train associates, for partner compensation, for decision making, and for governance and partnerships. And yet, while wrestling with these questions, firms are having to make short and medium-term choices when a particular client asks about whether LPO is suitable for their matter. Law firms are asking themselves, should we do this at all? Which activities are suitable for legal process outsourcing? To whom should we outsource? Where is it safe to outsource? Should we build our own center? Should we take the lead, or should we wait for clients to come along and prod us into it? As you and your partners work through these issues, here are some lessons learned from the mistakes of others. First is you really need to recognize what clients are really asking. They may be asking about LPO, but they care about efficiency, they care about recognition that they are under pressure, they care about alignment of their interest and yours. And the answer to those interests doesn't have to be LPO. You can be responsive to their interests without necessarily outsourcing. For example, you might sit with them and review the portfolio of work that you do for them, and think about what are the things that you are doing for them that you shouldn't be, and what are the things that you aren't doing that you should be. You might think about delegating and managing some of the work that you shouldn't be doing for them because you're not best suited for it. For those services, you might want to use your network to help clients place and manage the work, for example, with some best friend firms that are in lower cost locations. And you should explore alternative fee arrangements. Clients want efficiency, they want predictability of costs, and you may be able to meet that with a fixed fee or another arrangement instead of outsourcing. Second big lesson is don't treat outsourcing as zero sum. It's not about whether you used to hire people to do this work and bill for their hours at a markup. It's about what is the value proposition that clients need today and how to deliver it. I think you need to analyze what it costs you to deliver the different services that you deliver. You need to consider which of those things truly connect to what is distinctive about your firm. And you need to ask yourself, what would make you more competitive and sustainable? Third big lesson is you really need a plan. You can't treat every situation as a one-off to be decided by the individual partner on the matter, at least not for long. It's okay to experiment, but there are risks to be managed, there's institutional learning, there's economies of scale, and there's tremendous benefit from integrating LPO properly into your firm's value proposition. Learn from your early experiences, but then use that knowledge to make good choices. For example, should we reduce our overhead? It's not only legal services that can be outsourced, but IT, billing, business research, and more. Should we use LPO to go after new work? If we're priced out of some work today, can integrating an LPO improve our value proposition? Which clients and which practices are most vulnerable? Where are we going to see this pressure next? And what do we need to change in our own organization in order to make effective use of a third party? Getting partners on board is not trivial. The process that you use to develop these answers in a law firm partnership will also determine how effectively you can implement and use it. If you want to know more about what your clients and your peers are learning and participate in this dialogue, check out my blog at www.dannyertel.com.